When I'm in court, my adversary does not exist. It is me and the judge, and they're the only people in the courtroom. This is not a spectator sport.
Welcome to Between the Briefs, a podcast by Steno. We're here to bring you practical tips, expert insights, and real conversations about the pretrial process, court reporting, and the legal technology shaping the future of litigation. I'm your host, Adrian.
And I'm your host, Joe Stevens. Whether you're an attorney, paralegal, or just curious about how technology is changing the legal industry, we've got something for you. Each episode will break down complex topics, share behind-the-scenes intel, and talk to the people leading innovation in and out of the courtroom. So grab a coffee and let's get into what's happening between the briefs.
Hello and welcome to Between the Briefs, brought to you by Steno. We're your hosts. My name is Adrian.
And I'm your co-host, Joe Stevens.
In today's episode, we're thrilled to welcome Joel M Ferdinand, a distinguished business trial lawyer and co-chairman at Pierson Ferdinand LLP. Joel has built an exceptional career handling sophisticated business disputes, including complex litigation involving mergers, contracts, insurance claims, and much more. His aggressive yet practical approach has earned him a reputation as a top litigator in both federal and state courts.
With over 20 years of experience in the legal field, Joel has represented a diverse range of clients, from large corporations to family-owned businesses. His insights on handling high-stakes cases, navigating corporate governance disputes, and leveraging technology in litigation are invaluable, especially in today's evolving legal landscape.
Joel, welcome to the show. It's a pleasure to have you with us here today. How are you doing?
Adrian, Joe, thank you for having me. I'm doing great.
Of course. I'm really excited that we can bring you on. So how about we just get started at the beginning? Tell us, what got you into law and becoming a lawyer in the first place?
So if my mom were on, she would tell you when I was a kid, she would pay me 25 cents to shut up. I've always wanted to be a lawyer since I was 7. I mean that. It's frankly, it's the only thing that really made sense to me. I love to help people, passionate about helping and solving complex problems into the simplistic. Always been.
What did that path look like for you, Joel? Were you sort of already thinking about law school in undergrad? Did you go straight through?
Yeah. So it's all I wanted. Undergrad, I went to Rutgers in New Jersey, New Brunswick, New Jersey. I did pre-law. So I was either going to be a social worker, a teacher, or a lawyer, right? Really wanted to be a lawyer. I went to Hofstra for my first year of law school, then Rutgers, Camden. I matriculated quickly. I skipped a year of college. My dad kind of asked me to stay on that last year and enjoy childhood. Thank you, Dad. It was the right decision. And I went right to law school. I never looked back. I started my career at Fox Rothschild in New Jersey, really cut my teeth as a litigator and started trying cases, which I loved doing.
Love that. Now, I see here that, you've been dealing with a lot of sophisticated business litigation. What does that exactly entail for our audience that isn't familiar with that phrase?
Sure. So I get bored easily. I think that lots of people, they hear lawyer or they hear litigator and they're like, you're like Harvey Specter. No, we're ethical, right? Nothing gets to court that quickly, but we love the complex. So I learned early on in my career in commercial litigation doing business, there's nothing that we should not be an expert in. So I'll reverse the double negative. You should be able to be an expert, loose quotes expert, in anything within 2 hours, except a hard science. So from environmental law to breach of contract, uniform commercial codes, insurance, regulatory, directors and officers, business divorces, which is my favorite. There's not a whole lot construction that I haven't touched in my career or tried a case on, from New Jersey to Alaska. It's fun. So we really, I focus on businesses more often than not because I recognize we're expensive. Businesses tend to have more complex litigation. They can handle the expense of making the complex simple in short order.
Joel, what's your sort of mindset when it comes to trial itself? I'm always interested in this as a practitioner. Some people describe trial as, well, this is a last resort if we don't settle the case. And other people sort of lead with the idea that this is the strongest weapon that we have as litigators, is not just the threat of going to trial, but a track record of success in the courtroom. How do you think about trial when you're sort of beginning to talk to clients about their cases?
Yeah, it's a great question. So I think there's a stark difference between litigators and trial lawyers, right? Most litigators are afraid to try cases. They do the blocking and tackling, which is necessary strategic work, even depositions, the oral advocacy of it. Trial lawyers want to go to trial. I do not want to go to trial for my clients. It's expensive. We make money. Not every trial leads to success for a client, even when we win. You may outspend a case, and it's a sad practical reality. I believe that our judicial system works and it works well, but the cogs of justice are slow. So I start every case with an eye toward trial. I look at the endpoint, and I think you have to look at the endpoint first. And then we work backward from the endpoint. So when I train this to junior partners or other attorneys, I believe that all litigation, all trial is a beautiful Shakespearean play. Does not matter if I'm in federal court, state court, in the UK, there is a script. And the facts might change, but the script is the same. Every case is going to start with a demand letter or something similar, or a complaint, arbitration filing, some type of international filing, something sets you off. Then you have a certain application of response. You're filing a motion to dismiss or demur, depending where you are, an answer, a motion for more particular statement, motion to strike, motion for judgment on the pleadings. And now we start moving. When you start moving, lots of attorneys wait. Why? I've already thought it through. You know the case best then. If you've talked to the client, you know the goals up front. And I mean up front. That is the first question I ask my client. What are your goals now? We can talk about them once a week, once a month, once a quarter, once a year. Cases progress and they take time. But you have to know up front where your client wants to go. Now I'm thinking trial. So I'm going to draft interrogatories, document requests, requests for admission to deposition notices, corporate designee deposition notices. If it's a land case, request for inspection on land now, and get 11 months of litigation done now. So listen, gentlemen, litigation trial, it's about pressure, right? Whatever the facts are, and we have to be honest with the court, honest with the tribunal. It's of the utmost importance ethically, and nothing is more important than ethics. However, it's still about pressure. So you do it up front, you remain proactive, you remain passionate, but you're going to hear me say it so many times today. Proactive. Reactive lawyers suffer from stress. I'm not stressed about work. I love what I do. I'm thinking through to the end. And if I truly, and you learn this in law school, I think people forget it. If you know your strategy, if you know your closing, not the opening, the closing at inception, sure, that adjusts. Facts adjust, facts come in from depositions, whatever, but I know it up front. And you roll with it all the way through. Now there's no surprise. You're strategic and consistent. Now the client knows a realistic budget, and I mean realistic, within a percentage probability, even dependent upon the other side. You have some law firms that really pressure. Everything's a fight. Sometimes it's not. You have better adversaries. Knowing up front is the name of the game. Right? We have to de-stress our clients. We have to de-stress the court system. This is what we do. I have court tomorrow. I'm not stressed about court. I have not prepped yet. I'll prep tonight. I love doing it. It's fun. For my client, not so fun. So we have to think in advance.
Makes perfect sense. Now, you mentioned you have to get all the facts up front, right? You have to get the story. What questions do you ask your client? Because I feel like a large portion of your job, it sounds like, it's client management and really getting those facts in the best way possible. What questions do you like to ask so that way you can actually dig into the root of what it is they want and how you can get there?
It's a really good question. What if I told you that all clients lied? Not intentionally, right? So I don't do car accident cases, right? I do more complex commercial litigation, but I've done personal injury too, and I think it's the same thing. Adrian and Joe, if you both got in a car accident and you were driving separate cars, Adrian, you may see that you had a red light. Joe may see that you had a green light. Doesn't mean you're wrong, doesn't mean you're lying, it's your perception. And that's difficult. It's our ground, and our job as attorneys to find the truth. Sometimes the truth is a middle ground when two reasonable human beings see something differently. So the first thing I start with my client is tell me your story. And I tell you, this is the most difficult part of the job. We have to shut up and listen. Anything else? Anything else? Anything else? Anything else? Right? Anything else? This is what's lost. Juries, judges, I think they get bored because of the morass of litigation, the morass of trial law. It's hard to make it sexy if we're talking about a contract. Anything else? And we have to get to that outermost layer of there is nothing else. And then I start over. And now I will cross-examine my clients. Let me understand. What you're telling me is you signed a contract, right? And the contract was signed on June 5th of 2025. And you heard the other side say, but the contract has an integration provision that says the four corners of the contract are it. Did you have an email that said that? And we slowly and truly, we start going through it. And now I understand the facts from their circumstance. Well, that leads me to trial because I know their circumstance. That doesn't mean I know the other sides yet, right? And I think that the reality of law is that we see a middle ground. I wish 2 + 2 was 4 in law, but it's not. And it's why we're able to charge what we charge, It's why we're able to flex on the fly in a case or a deposition or during oral argument as facts change. The truth is still the truth, but different parties are going to see it differently. That's the fun part about our job. So I think at inception, you're asking your client the facts from their circumstance. We're understanding from their ideal and their situation. Where I say clients lie, and I don't really mean clients lie. I'm being cute. I think clients try to tell you sometimes, often, what they think you want to hear. Having watched TV, watching Harvey Specter, and presuming how it happens. I think it's our job to slow it down and really find out the good, but the bad and the ugly. I want to know everything up front, and I want to know what the client's worried about, not what they're telling me, but implicitly telling me, so we can break it down, slow it down, and find out what their real concern is. That tends to be the linchpin fact or facts that make a case hinge for a winner or loss.
Speaking of these clients, sort of the early moments with a client around intake, before you even sort of lock into an agreement, what are the red flags that make you say no?
Oh my gosh, honestly, this is more lawyer to lawyer advice. We ask for a retainer and a client, huh? Or they've had a lawyer before me or two or three lawyers before me. Can I tell you, in my career, particularly with my experience, I tend to be not always the first lawyer that comes in, but the second or third to come clean something up, to ratchet up pressure, to become proactive, to take something to court. That's already a red flag. If there was a lawyer before me, what happened? Did the client not listen to the lawyer? Was that lawyer sloppy? Unfortunately, that happens, right? Did the lawyer miss something? That happens. Did the lawyer not act proactively enough and not get the facts or the documents and come in on a case theory that's incorrect? Right? It doesn't mean it's wrong, but it's incorrect for the facts or the client or an adversary. That's always a big red flag. The other big red flag I have is a client that actually lies. There's a difference between perceived truth and an outright lie. So I tell all clients, and I repeat it to them twice at inception. So I'll repeat it twice to the podcast and the audience. If it is not in writing, it does not exist. I'm going to say it again, right? If it is not in writing, it does not exist. And what I do in commercial law, the red light, green light's difficult. If I'm doing an environmental case, a contract case, a business divorce, an operating agreement, there's going to be something, a text message, a photograph, an audio recording, something in writing. I expect what my client's telling me to be backed in writing somewhere in this case. If it's not, there's a bigger issue, right? And that gets a little difficult, and that raises a red flag where typically I want to pull out. The big thing I have is at my level, listen, I'm not the greatest lawyer in the world. I'd like to tell you that I have an ego. I don't. I'm humble. There are better lawyers than I am. I will be the most prepared human being that walks into a courtroom. I put everything to memory, verbatim. I don't leave anything to chance. I'm a control freak. We have to control as much as we can in court because it's live testimony. It's a live judge. It's a live adversary. Things change. But a client that does not follow advice is a client I can't mesh with. Just because I have a way of doing it doesn't make my way right. So we're going to talk about our law firm today, Pierson Ferdinand. Pierson Ferdinand, Michael Pierson, I believe, is the elite law firm of the future. We're a partner-only law firm. We've been in existence for 18 months. We already have 236 partners. We'll do over $120 million this year. It's a wonderful model. My partners are very diverse. Just because I say how to do something certainly does not make my way right. There's 1,000 ways to get to bingo. So I want different voices, attorney voices in the case. But once we pick a strategy, we recommend it to a client. If the client starts to balk, they have the wrong lawyer. I can't have a client tell me how to do my job any more than I have clients that are electricians. I can't tell an electrician how to do their job. I have no idea what I'm doing. I might be able to wire something, but I am not an electrician, right? I think it's the same thing with law. There's different tools for everything that we do. And there's different lawyers for every type of case and client personality. If you can't mesh with your client, that is the biggest red flag. Never ends well.
I can definitely see that being the case. Now, you mentioned earlier how, if you can't become a subject matter expert within 2 hours, then it's probably not your wheelhouse. What do you do so that you can become acquainted with an industry that you may not be very familiar with, especially at such a quick pace?
Yeah. So my first law firm ingrained this into us. It's a great firm. I had incredible training. Really, we did. You have to spend, I think, the first 5 or 6 years of your career learning 20 years of law. I had a Had an office managing partner at the time, James Rudy. He's a wonderful guy. Jim told me when I was a third year in law school at Rutgers, listen, you have to spend the next 5 years knowing 20 years of law. Right? Exactly what I just said didn't come from me. And he was right. I think to be an effective trial lawyer, you're working 18 to 20-hour days your first 5 to 10 years. That stinks. That's not lost on me. It's an awful profession. It can destroy interpersonal relationships. It can destroy marriages. There's no such thing as that balance. And you have to try to find it. Family's more important than anything. But as a junior lawyer, that is your job. You have to live it. You have to breathe it. You have to know it, or you cannot practice at this level. And at some point, you get good enough. But listen, I don't recognize myself when I look at the video camera anymore. I'm older now. I'm gray, right? It's cute when you're a younger lawyer. No one takes you seriously. You're hoping you have gray hair. Now I cut my hair shorter because it's so gray. I don't know what happened. It still takes me, if I have a different business divorce type case and it's in a pharmaceutical for a pharmaceutical company, I have to go learn pharma. So I'm a voracious reader when it comes to casework. I don't have time to read for pleasure. I read industry publications. We find out about the client's verticals, and not just one vertical. Most companies have a core nucleus and they have branches coming out with all these different business verticals. You have to know them all. You have to have the ability to explain to a client, even if you're trying a case or litigating a case unrelated to the issue. Hey, while I've been working on this case, I noticed that your scale can be impacted because of X, Y, and Z. Might have nothing to do with the case, but we learn it during that case. They need to know, and they need to know up front. And you can't be afraid to tell a CEO what's happening. I think that's a problem. I think a lot of times lawyers get blinders and they can only see one set of facts. They can only see one way a case works. If I can impact the scale or optionality of a client through litigation, I better tell them. Otherwise, what am I? I do one case. I don't want to be a litigator or a trial lawyer or a trusted business advisor. My clients are clients for full service. That's how I'm able to do M&A work and litigation. And listen, I shouldn't spell M&A. We don't dabble at Pierson Ferdinand. If I'm doing an M&A deal, I'm bringing in my partners in the corporate department to help me with the M&A deal. But I stay active and involved in the negotiation and the deal work because that's what our clients expect, right? You have to learn it all.
Joel, can you talk about your law firm's structure and how it's different than, why it is the vision for the future?
Absolutely. So we are a distributed law firm model. So this is my home office. This is not AI, right? Everything we do is over the top. I have 236 partners and we all work remotely. We have systems and technology that are ISO 27001, SOC 2, Type 2, and GDPR compliant. Our security is second to none. We make sure of it. We built it from the ground up with really trusted vendors that we use that have been incredible. We built a lot of our own tech behind the scenes as well. And we run a remote environment where we are in over 40 states with individual partners and 6 countries, right? We're in almost every time zone. It's very intentional. So our clients have a unique, consistent set of services from partner to partner to partner, right? It's our job, Michael Pierson and I, to reduce the non-billable for our partners. So as hard as we focus on our clients, and we do, clients are very important, our partners are also clients. They have to be happy. And I think in the traditional law firm modeling, that's what's been missed. You have so many lawyers that suffer from a really severe form of PTSD. I'm not being cute about that. From a prior job where they're made to feel less than, to a judge that'll yell or a client that yells, they need to feel that they're enough and they're empowered, but they actually need to be empowered. What we've done with our law firm is exactly that. We want our partners to know they're loved, they're empowered, and they're enough just the way they are. We hire elite, excellent lawyers that are really good human beings first. And we focus on the human element of it. Happy lawyers make better lawyers. Better lawyers make better clients make better court results or M&A results or IP results, labor and employment results. And it's the truth. I don't want to work with a narcissist. I want to work with a client where we share the same values. We share the same ideas, and we can be different. We are radically inclusive. We love diversity, but we want to work toward the same objective. That's what we've done in the law firm. And I can tell you affirmatively as of today, we are one of, if not the fastest growing law firm on the planet. It's really exciting.
It's incredible. Now, you mentioned the structure, and I want to dig into that a little bit deeper. Does this mean that you don't have associates in your firm or like the typical structure of like paralegals and support staff? Is it just strictly all partners that then have technology that enable them to do those jobs without those positions?
In large part, yeah. So we're a partner-only law firm in the States. We have a couple of junior partners and a couple of associates out in the UK, which are wonderful. We heavily leverage technology. So we have paralegals throughout the firm. We have a paralegal pool, a bank, that are partners both in corporate, or I shouldn't say both, in corporate, litigation, IP, and labor and employment are four main practice areas with 98 subspecialties underneath them. Can all use as and when they see fit, and our paras are second to none. Michael's worked with one for literally his entire career. I've worked with another for our entire career. We're actually looking for more right now. Uh, Through technology, we deleverage. So it's our job, me and Michael, to reduce the non-billable. So if you were a partner or an incoming partner and we were interviewing you, Michael and I have personally interviewed over 890 partner candidates since January 1st of 24. And we do all these ourselves, along with one of our partners and recruiting head, Edmund Brown. What I would tell you is it is my job to reduce your non-billable. I have to make your life happy. So through technology, you don't have to draft engagement agreements. They're important. It's a necessary part of the job. We have 91 pre-approved forms that are compliant in all 50 jurisdictions and almost every country overseas. It takes our team less than 60 to 90 seconds to auto-populate these, make them correct, and get them out to the client for signature. In most law firms, that could take weeks. Our conflicts clear in a matter of minutes, not hours, not days, minutes. We have a conflicts team headed by Renee Moyer, whom I've worked with, I mean, literally my entire career. She's incredible. The team that she's put together is incredible. We love on our teams so that they are empowered to do the best job possible. And through a technology backing, some of which we've used off the shelf, some of which we've recreated and coded with some really incredible software engineers, who we've come to very much trust through open APIs, to make it one of the fastest systems possible to deleverage the non-billable and get our attorneys to what they're meant to do, represent their clients, right? I think that there's so much focus right now, like AI. You have some camp of attorneys that are petrified they're going to be replaced. You have some camp of attorneys, and there was another one of these my partner sent me in Massachusetts yesterday that just got sanctioned for citing cases that don't exist, and they're using it too much. You have another set of attorneys that are like, well, maybe this is a good, listen, AI is great. It's a tool, just like Lexis and Westlaw is and was when we were coming out of the books, going to legal research online. Technology can be very favorably used to help attorneys deleverage the non-billable and deleverage the billable. You have a whole host, a generation of attorneys that think deleveraging the billable means they're going to make less money. Well, if we can pass cost savings on to clients, we should. Why wouldn't you, right? Not everything needs base level legal research. Listen, if I'm doing a business divorce case, I do hundreds of these a year all over the country. I don't need to start with basic research. I know the research. I might need to go back in and pull a couple cases for that jurisdiction, but I know what the law says. That's my bailiwick. Why would you charge a client to do more?
Joel, how are you guys using AI? And what sort of specific ways is it in basically jumping into your workflow?
Yeah. So we have very specific AI tools that are GDPR compliant. They're not all, right? So with what we do internationally, our security is very important to us. It has to be because it's important to our client. We use an AI tool. For example, I could put a load file in and ask it for a timeline. I could ask it to look up cases for me, draft a memo. I can, in a very encrypted vault, specific to us, where it learns for me, but not for the outside world. The outside world can't see it, so my clients are safe. Our clients are safe. Start uploading case files and asking it for timelines where it thinks something's off. Do you think someone's lying? Junk in is junk out. So you treat it like a high level associate, right? I'm asking it very specific prompts, very specific, and I'm getting very specific outlays. Does that mean I don't look at every document? Gosh, no. I have to look at everything. It's still my malpractice. It's still my reputation. It's still my ethics rules. I think that's where people are missing this. Just like going from internet research, from book research, you still have to read the entire case. You still have to make sure it's accurate. You still have to formulate the argument. Listen, we have AI vendors that are pretty insistent, and I think they might be right, that in the next 6 to 9 months, there might be able to be an outflow that sounds like me. In writing, I love to write. It's one of my most favorite things to do. I love to gild the lily. You take the complex and you make it simple. Simple in court works, complex does not. It just doesn't, right? Complex, you lose. You have to make the complex simple, but it still needs to sound like us. Well, I'm able to upload past briefs I've done, and now it's starting to sound more and more like me. I still have to slow down. I have to track change it. I have to key it for that judge. I have to key it for that specific client, my adversary. I don't think it's going to replace us, but it should be used. And I think it can be used. This is not an endorsement for ChatGPT, which is wonderful, I think, for storytelling. I have a 15-year-old. That's crazy. I just aged myself. He's going to be 15 in July. If I want to do a bedtime story, he's too old for this now, and I want it to sound like a pirate. ChatGPT, draft me a bedtime story for Finn, my son, and and his cousin, my nephew Jameson, that sounds like a pirate. That's fun. It's not what I'm talking about. I'm talking about high-level legal tech tools. So Michael and I went to Legal Week in New York a few months ago. There had to be 50 new vendors, the new kids on the block with AI. Not all are created equal. Does that mean they don't have great products? No, they're wonderful products, but not all are created equal. There are very elite products out there that are getting more and more elite over time. There are scraping tools that can help organizations better help their employees, their partners, their staff, if it's a law firm, get to yes for a client in legal and ethical manners. This does not replace us. We still have to be lawyers.
Completely agree. That human element can never really be taken out, right? We use it as a tool to empower us, but it's so necessary.
Listen, I suspect there's some AI vendors who are like, you're wrong, and it is going to replace some of it. I think it will. Uh, I don't know that it replaces me going to court. I don't know that it replaces me drafting a brief to make some really complex point very simple and understandable to a jury or a judge, right? There's still that level of experience. You could upload the past 19, 20 years of my career. I don't know that from an AI perspective, my brain becomes that for legal AI. Maybe it does someday, but I still think it's a tool. And it's a tool that if you're not using it from a legal perspective, you're going to be lost.
That makes that very true. I want to have a follow up with that. We once had a guest on this podcast, Andrew Finkelstein, who said, "Can't let the facts get in the way of a good story." Right? And he didn't say that in a means of like the facts
No,
are
it's
not
he'd
important.
right.
Yeah, they're very
Adrian, he's
important,
right.
but you need to like show them in a very appropriate manner that tells a proper story. What is your way of telling this proper story? Once you've simplified what it is you want to tell, how do you go about telling it?
The case I have tomorrow, it's actually in New Jersey, is so complicated. Doesn't need to be. It's just been pled in such a complicated manner. It's not. You stick to 2 or 3 points. So what I was always trained, and I've always done it. I, this is how I became editor in chief of the Rutgers Journal of Law and Religion. It wasn't voted on popularity. The people that ran got up and made a presentation. I got up. There was a whiteboard. I took a marker. I put 3 points, and I turned my back to everyone. I was done with my 3 points. I turned around and I presented my 3 points. It caught everyone's attention. It caught everyone off guard, and it gave me a roadmap immediately within 5 minutes to make my presentation and my points for what I was going to do for the next 12 months. I don't think that's dissimilar. So I had a great trial professor, his name was Joel also, that always made the point, and he would say, for every shtick, there's counter shtick. So for everything you're going to say, the other side's going to do it. So Joel, if you get up and you have a whiteboard or a piece of paper and you start drawing stuff and you leave it up after your opening and you sit down, I'm going to get up, I'm going to take a different color marker. I'm going to start crossing stuff out in front of a judge or a jury to prove a point. I think that's what you can't let the facts get in the way of a good story mean. It still has to be a good story, and it's our job to make it compelling, sexy if you can do it. I mean, listen, on the 4 corners of a document, this is boring. Guys, it is. This is boring. I have to amp up. I think part of a trial lawyer's job, part of a litigator's job is still to be an actor or an actress, right? We still have to imbue passion. So I think a life without passion is a life not worth living, right? If you're not passionate about what you're doing, you don't love your job, stop. It's not about the money. I don't care about money. You have to actually enjoy it. Every case that I have gives us the ability to tell a really compelling story. A story might be boring, but it doesn't mean that we can't make it exciting. And if you can't make it exciting, simplistic, and be able to tell it in a few points, you're losing. Now, listen, an opening, even a bench trial, an opening might take 2 hours. It could. Do you know 80% of cases statistically are won in the first 10 minutes of an opening? You still have to get to the point in the first 10 minutes and give a roadmap. Now, I might have to get in all the facts. Your Honor, you're going to hear testimony over the next week, 6 weeks, 8 weeks, months that says the following. Adrian's going to say, Your Honor, blah, 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 and now I'm a truth teller. But you have to forecast it and get specific. But I have minutes to get to the point and to outline everything that's coming. I think if you don't do that, you lose an audience. But look what happens to TV or movie. Some of my favorite movies, the timeline skewed. And it starts at the end, and then it goes kind of the middle and back to the beginning and back to the end. It's famous. Quentin Tarantino is famous for this. Look at those movies. You get sucked in, not just because of the timeline, but because there's a preface, and then everything just has this beautiful bow at the end. That's our job, right? I think the problem is this dumb device. We have the attention span of gnats. Yeah. So you still have to highlight very quickly where it's going, or you lose your audience. And I don't think that's unique to trial law. I think that's unique to litigators, to my son at 15. He's going to be a freshman this year in high school. When he's giving a presentation, it's the same thing, right? It's television, it's media, it's print, it's these podcasts. You did the same thing. You start it with a 30-second intro.
Joel, the other thing that matters to me in being in a courtroom is, and I think obviously to a judge or a fact finder of any sort, is authenticity, right? Your style might not work for Adrian. And sometimes the more boring style actually comes across as authentic if that's who that person actually is. Let's flip it around for a second. What do you think are some pet peeves you have inside the courtroom as you're watching other practitioners, or things that you just turn you off?
I really hope, Joe, that adversaries don't watch this, because you're like, is that me? One of the biggest things that turns me off is an adversary that does this, and they start looking at their opponent. Do you know when I'm in court? And this is, I guess this is more unique now with Teams and Zoom. Tomorrow, I'm going to be in Atlanta. I live in Brazelton, so I'll be in Brazelton for court tomorrow in New Jersey. Right? It is far more rare now on a lower level appearance. And when I say lower level, I don't mean a case. Tomorrow's it's a motion Friday. They're a very important argument, but it's not a summary judgment. It's not a pretrial conference. I don't physically need to be there. When you're in court, when I'm in court, my adversary does not exist. It is me and the judge. And that they're the only people in the courtroom. This is not a spectator sport. I don't care what my adversary says. It is me and the judge. I find that younger attorneys, younger in years of practice, not in age, make it really personal. Why? I don't say you. I don't say Mr. Stevens. I don't care about you. No disrespect. It's your client. If your client is Mr. Stevens, then I'm going to say Mr. Stevens. But honestly, I'm going to say plaintiff or defendant. It has nothing to do with the attorney. In court, it is me and the judge. Biggest pet peeve. They look at me. Well, Mr. Ferdinand said, I didn't say anything. I'm representing a client. And we could be best friends as adversaries, and I try to be with my adversaries. They're doing a job just like I am. It's not a war. It drives me stinking crazy. The other thing that I think is nuts, I had this happen a few years ago. I walked in, I had a plaintiff. This is actually New Jersey too. I'm from New Jersey. Could you tell? I still have lots of cases there, despite the fact that I'm in Georgia. So I had an adversary walk in on an order to show cause hearing. It's a hearing. This is a glorified oral argument. There's no testimony. There's no witnesses for this. He filed 13 of them across 7 different jurisdictions for the same day. I walk in, and before I can open my mouth, he puts up a storyboard. Your Honor, objection. What is happening? It's an oral argument. Listen, you can prove your point with demonstrative exhibits, but there's a time and a place to do it. It was absurd. The third thing, I'll leave it at 3, that drives me nuts, and I've seen this more times in my career than I can tell you, is an adversary that brings a client to court. If it's a trial or there's testimony, I get it. There is no place for a client in court. This is not a spectator sport. And you run the risk that a judge sees a client in the gallows and starts asking questions, because someone that wears a robe always reserves the right. It's their courtroom. How sloppy is that? And I've seen it happen. And then I've also seen judges react like, wait a minute. Who is here and why are they here? They're entitled to see what they're spending money on. That's okay. But if they're not providing testimony, I don't see the utility of having a client in court. It's our job as attorneys to make the argument and then immediately, and I mean immediately, simultaneously respond to the client and report back. So our cornerstones at Pierson Ferdinand are professional, responsive, trusted, and humble. There's no coincidence that those are my cornerstones and Michael Pierson's cornerstones as well, and from a personal perspective. When I say responsive, my clients expect me to respond within 60 minutes, 24/7. If I argue something before I leave that courtroom or tomorrow when I hang up on the Teams meeting or Zoom, whatever it is, I'm already ready to my client. Dear client, I write to confirm this is what happened in court today. This is what the judge asked. This is what my adversary said. It has to be immediate. I've seen some crazy stuff in court, though. Joe, really.
Yeah,
Sounds
it's an
like
interesting
it.
theater, isn't it? Yeah.
Yes.
Now, I would love to hear your take on this. Now that everything is more digital, people have shorter attention spans. I feel like this is also going in with the newer generation of people becoming attorneys. Do you think this is going to affect the newer generation of attorneys that are coming into the workforce and having to conduct trial um, with this digital era that they grew up with? A lot of times the soft skills aren't exactly there.
I'm laughing because you ended with soft skills, and my son goes to a Christian private school down south, and I love the school. I'm on the board, and they're starting to teach a class this coming semester on soft skills. Listen, I don't know how to better imbue this, and it's not just that generation. I'm a hiring partner. I've interviewed over 890 partner candidates here at Pierre Ferd. I was a hiring partner at my last firm. I've interviewed thousands of candidates. I don't care if you're 80 years old or you're 22 years old. Some people just do not have the soft skills, and law school certainly does not teach them. Right? I was a noob in law school. I'm the front row guy that raises his hand. I was top 5 coming out of my class. It took me 2 years to become human again and look up and get out of the books. My wife's a lawyer. She used to make fun of me for it, right? Like, she's like, hey, babe, can you be normal? No, I couldn't. All I knew how to do was study. I think that moving to a digital era is really important. I think it saves a lot of money for clients. I think that being able to do things like this and not be in a studio and in person is a talent that you both have. And it's not easy, right? It's not. I mean, we can be on video and this is clear as day, but it's very different not seeing my mannerisms. Am I wearing pants? I am. Right? But you wouldn't know. Like it's a whole different generation and an oddity. I tried one of the first arbitrations during COVID remotely. And there was a learning curve. Listen, I'm taking live testimony, and there's a different skill set in that regard. Taking live testimony from witnesses that I've subpoenaed, that I've never met, that I didn't depose because it was AAA, so you don't get depositions. I think it added about 25 hours of testimony. I do, and even introducing documents, there's a whole different skill set for paralegals or lawyers to be able to do this and watch now, because I can't see you other than your screen. So Mukti Patel, she's a co-chair of our litigation department, one of my dear friends. She's a mentor at Fox Rothschild. Been working with Mukti literally my whole career. She's a powerhouse. Mukti's deposing, cross-examining an expert during this arbitration. We tag team the witnesses, and I'm watching, and I think it takes a second set of eyes now. And I'm watching kind of push back, and she's in her outline and she's focused on the witness. She did an excellent job. I said, hold on, stop, objection. What? Sir, what are you looking at? The whole time the guy's looking down. This expert has notes and has prepared something. Thank God there were 2 of us looking at it, because she would have caught it. She's an excellent lawyer, but we saw it between the 2 of us almost immediately. There is a whole different skill set to do this online. In court, that crap would have never flown. The judge would have seen it immediately. I would have seen it. I would have tore that witness apart. It's different. And really now, I do think it takes 2 to tango. So I say this isn't a spectator sport. I'm a fervent believer that in trial work, you need 2 attorneys, minimum. It's not to bilk the client. If Mukti is doing one thing, I'm doing something else, we're not both going to bill the client for it. That's obnoxious. And I think it's a violation of the rules of professional conduct, just my 2 cents. However, it takes 2 people to watch. And on something like this, I can't just be laser focused on one tile. Now I have to look at the judge. I have to look at the witness. My adversary's on the screen. His client might be on the screen. How do you flip through quickly enough to really feel it and understand what's happening? Right? Completely different now. When you're in court in person, I can take all that in by myself easily on this screen, whether this is a 80-inch screen or it's an iPad that's 13 inches. It is completely different. And Adrian, you said it, man. I'll double down on it. There's a level of soft skills that generationally are missing because of this dumb device. This is great. Can I tell you, I miss the days of an actual fax machine. But I just aged myself, right? It really, it's not a matter of being quicker. It's a matter of seeing everything. And it's the unspoken that is more important in trial work and litigation than the spoken sometimes. Really, more often than not.
Yeah, I would totally agree with you. I think it's a great point. I teach at the law school here at Texas Tech, and I get students all the time. They say, what kind of classes should I take to become a better trial lawyer? I'm working this summer. What should I do? And I'm like, look, I can teach you evidence. I can teach you, get the reps. You can figure this out. Sometimes I do think that the best thing they can do is actually go and bartend or try doing some improv or something that really hones in on what Adrian was just talking about. I wonder if you feel the same way.
100% agree, Joe. So I've had a job since I was 11 years old. I'm not exaggerating. The only time I stopped was to study for the LSAT. Stopped for 3 months and then I got a job again. I have worked full time since I'm 11. Right? I have been a camp counselor, an ice cream scooper, a car detailer, an assistant manager in a clothing store, a salesperson. There's certain things that I just don't think can be trained, right? So I get questions all the time. I'm blessed with a large book. How did you do it? I didn't. One, I know where it comes from, right? Faith is everything in my life. But two, you cannot be taught sales. I could teach you a class. If you don't have the skill set, there's nothing I can do to make you this. And this does not mean this is the best. You said it right. I'm going to turn off some people. I have the personality. You either love me or you hate me. There is no in between. I know that about myself. My dad's a car salesman. I grew up watching it. My dad could sell anything. So can I. Nothing he taught me. I was born like this. It's my personality, right? The best class I ever took. So when I was at Rutgers Law, I loved law school. My wife hated law school. I loved it. It was educationally, socially, it was a time in my life, I think, where I excelled more than anything else. They offered a 6-credit litigation class with this guy, Professor Alan Stein. And it was 2 federal court judges, magistrate judges, Judges Antonio and Joel Rosen. They're powerhouses, all right? In a 6-credit litigation class, 6 credits, they gave us a fake fact pattern and said, go. And they brought us in court in a safe environment and kicked the crap out of us from a pleading perspective, an oral perspective, all the way up to a pretrial for a semester. And at 6 credits, it's a scary class because if you screw up, you have a problem, right? After I took that class, they let me stay on as a TA for the next year, and I helped them with a fact pattern, and they let me help assist with the case. Best class I've ever seen. You're seeing this. Wisconsin now has an apprenticeship program. This is coming back. I think the biggest failure we make from a professional acumen perspective is the idea that law school teaches you how to do this. It doesn't. Joe, and listen, as a professor, for you, yeah, I mean, listen, you're right. You can teach contracts and tort, real estate, whatever. Negotiation. It does not teach you in a true environment how to get the crap kicked out of you. And look, one of the things we focus at Pierson Ferdinand, the law firm, is mental health. So this isn't a funny joke to me. This is one of the most stressful professions out there. Lawyers are twice as likely to think about suicide than a layperson. That's not okay. It's because, and I'll keep it in our circle, we're litigators. We go to court. I got a judge that wants to hold me in contempt or sanction me. I got an adversary that, even if I'm right, wants to kick the crap out of me. I have a client that is going to yell if I lose, and I certainly can't guarantee a result. It's malpractice. You have facts that I can't control that have been done before I get here. I have a clients, third-party witnesses we can't control through live testimony. Talk about a stressful profession. The best way to learn how to do this is to do it. But with the stakes we're talking about, if I'm litigating a multi-billion-dollar case, I cannot learn on the job. You can't. The best way to learn that is in an environment. So what I tell What I tell students that I mentor, go take clinic. I did the Rutgers Civil Practice Clinic, and it was amazing because I was able to represent indigent clients in Camden, New Jersey that had an $8,000 problem that to them was life ending, where I could go beat the snot out of an adversary and act like I act now, 19, 20 years later, on a case that meant the world to my client, meant the world to me, because I didn't have a billable hour quota as a young attorney. And that was my sole job, was to protect those human beings. That to me is how you learn. Right. And I think coming back into a larger form of apprenticeship program or a third year, well, let's be honest, your third year of law school. I took all my core classes my first year. You take one or two core classes, evidence two or evidence one, and your business corporations class. Now I'm done with my required classes. My third year of law school, I did not need. It's not a slight on any law school. They're important. What if your third year of law school was an apprenticeship program with neighboring law firms? High-end law firms that are going to train, and I'm going to say this word and I'm going to catch flack about it, haze these students. I don't mean haze them in an alcoholic manner. I don't mean haze them from you have to work 20-hour day. I mean, drop them on their heads and have them learn in an environment where it is baptism by fire, where they can truly learn. And we're here to pick them up and really elevate them. But now they learn and they're in a safe environment, working on actual cases where I'm not going to let them really screw up. I'm here to help, but they're doing real work. It's important.
Very important. I think that would really change the system, honestly. Just creating a actual mentorship kind of program where people can actually learn by fire, incredibly important. Now, we always ask this at the end of the conversation, and that is, what is your hottest take on the industry right now?
Joe and I are a little older than you, Adrian. So I'm curious if you agree. But listen, I one of my roles here, I interview partners for a living. I've lived through enough cycles to see that in a recession, small cases for litigation rise greatly. You start to fight over 100,000, 500,000, a couple $1 million is more meaningful. In an economic surge, larger cases get hotter. 50 million, 100 million, $1 billion cases. What I'm seeing right now is something that I've never seen in my career. Both are so hot and there is so much of an influx of work. I don't know how to keep up. And it's not just me. I'm watching this, we have 113 litigators coast to coast and overseas globally. We're watching litigation just skyrocket. And I don't think it's a result of people wanting to fight. I think it's a result of a little bit of a economic fear in a recession and a little bit of a hope for resurgence, and litigation is up. So the hot trend that I see, I don't know how courts are keeping up. And I think this helps from technology perspective, because it's much easier for me not to waste a judge's time for 30 minutes to come in and check in. All rise, judges on the bench, and then the judge is done, but we all have to shake hands, and now we're talking. I think this is speeding up courts a little bit to clear dockets post-COVID, which are still backlogged. But what I see in a marketplace, litigation is really hot right now, and I don't see it slowing down. And every lawyer with whom I speak on the litigation and trial side is saying the same thing. And this is a surge that I've seen for the last 17, 18 months. The only other thing I would say, and we talked about it today, is AI. What does it mean? Where is it going? And how the heck do you use it? And you have lawyers in those three camps we discussed, like, oh my gosh, don't use it. It's the devil. It's the future. Or they just lock, stock, and barrel use it and don't ask questions. Right. I think you're going to find a whole profession, and this is already starting in the marketplace, that teaches lawyers how to appropriately use AI. I think that you might see a resurgence of knowledge management departments in law, where the librarians are coming back and what they're teaching you is junk in is junk out. And the prompts you're using for AI matter. How you review it on the back end matters. How you explain it and disclose it to client matters. How you explain and disclose to courts that you're using it, because you should, even those that don't require it, matters.
Great take. Well, thank you so much for joining us here today, Joel. And thank you so much for our audience for tuning in to Between the Briefs, brought to you by Steno. Special thanks to our guest again, Joel M Ferdinand, for sharing his deep insights into business litigation, his leadership at Pierson Ferdinand, and his approach to handling complex disputes. And of course, Special thanks to my co-host, Joe Stevens, for another fantastic, and I mean truly fantastic, conversation.
Adrian, Joe, thank you so much.
Absolutely, Joel. This was fantastic. Thank you, Adrian, too. And everyone, be sure to subscribe so you never miss an episode. Stay tuned for more thought-provoking discussions at the intersections of law, technology, and innovation. We'll see you next time.
Up next on Between the Briefs.
There's two main tips I have for you. Number one, always tell the truth. Never make up facts. You're not going to win or win the case for us by your test. The only thing you can do is lose the case for us.
Stay tuned for the full interview coming to you soon.
Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts. And click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.